Case number 112701, Kevin Biglow v. Marshall Eidenberg and Via Christi Hospitals, Wichita, Inc.
May it please the court, I'm Jonathan Sternberg, and I represent the appellant, Kevin Biglow, who is the heir of Charlene Biglow. And I'd like to begin by asking for 3 minutes for rebuttal, Your Honor.
3 minutes is granted.
Thank you, Your Honor. This is a medical malpractice wrongful death case. My client's wife presented to the emergency room with shortness of breath. After being given a breathing treatment by the defendant physician, her heart rate shot up. The physician admitted her to the hospital for the night, and within a couple hours she had died of heart failure. He alleged, my client, who is her husband, alleged that his failure to diagnose or treat the specific heart condition she had was the negligence that killed her, and sued for wrongful death. The defendant was successful at trial, and my client appealed, arguing various errors in jury instructions and in the exclusion of evidence. Your Honors, we have 3 issues before the court on review, and I'd like to begin by addressing what was the first in the Court of Appeals and is the second in our petition for review. The district court's issuance of a so-called physician's selection of course of treatment instruction under former PIC 12311 was error that requires a new trial. Now, I appreciate this is a slightly peculiar issue for the court to have granted review on, seeing as the PIC committee deleted 12311 in December 2014, which was shortly after the trial below, and now recommends that no such instruction be given. But that said, it was given in this case, and erroneously so, and I thank the court for agreeing to review this issue despite the fact that its resolution may only wind up affecting this case. The law of Kansas is that a 12311 instruction only can be given when the jury is tasked with deciding whether a physician appropriately chose between 2 or more recognized courses of treatment. As 12311's own notes on use put it, quote, where there is a dispute as to which of 2 or more courses is to be pursued in administering treatment. When the facts don't warrant this, as in the Wecker case in 1996 and the Lee case in 2009, issuing a 12311 instruction is reversible error, because it misleads and confuses the jury as to the facts of the case.
Let me ask you about that.
Yes, sir.
When I read we're talking about instruction 15.
That's correct.
Which says where within which is the word where, lawyers use that, but just it should be when, but where within a physician's field of medicine there exists more than one recognized approach to an issue of treatment, it is not negligence. When I read that, that just tells me that we're telling the jury that if it were to find that there was more than one approach to a treatment, then you do this. Your argument is that there isn't a dispute about that. Well, why, if the jury's looking at this, why can't they just then keep going on if they agree with you? In other words, it doesn't tell them that there's 2 conflicting approaches. It just says, if you find one, then this is what you're supposed to do. And so, if I read it that way, it's hard for me to get excited about your argument, to really think that this is damaging you in the jury's deliberation. So,
sure. Well,
address my problem.
Absolutely, and I appreciate that. The jury is also instructed under PIC in every single case that they're supposed to follow the instructions, right? That they're supposed to read the instructions and follow them as written. I think the issue here is that assumes, Justice Biles, your suggestion that the jury, if they agree with us, that there aren't 2 approaches to a treatment, this misleads them as to that, because it says where within I agree, it should say when, within a physician's field of medicine there exists more than one recognized approach. There wasn't an argument about whether there was or wasn't more than one approach in this case. And in the Wecker case in 1996, the Court of Appeals reversed a 12311 instruction and basically rejected that argument and said, it's only ever appropriate when there are, when the question is, as in the Hibbert, Wamsley, and Foster cases, when there's an issue about should the doctor have, when the doctor is faced with a medical situation and he realizes there are two possible choices and he chooses one, and the plaintiff tries to argue that his failure to choose the other was negligence, then it's appropriate. In Wecker, however, there was a neoplasm found in the patient's cervix, and the doctor chose laser surgery. He only ever suggested to the plaintiff that she undergo laser surgery. The plaintiff said that, kind of like here, it's the converse of here, that the issue was not about course of treatment, because she said what he should have done was not treated it at all and waited for to see if it resolved itself. And despite the fact that only one course of treatment was ever even suggested, which is the case here too, as the defendant himself admitted on the stand, treating versus not treating is not about two selections of courses of treatment.
Why not? Why isn't that two options? Though, like, for instance, prostate cancer, they have watchful waiting.
Sure.
Okay.
Yeah.
Why isn't that a choice? And here we had, you're alleging there should have been some testing done. The other avenue was to treat the underlying causes of the hypertension, etc. And why isn't that a treatment option, to treat the causes of the a problem?
Sure.
The wording in the instruction is approach, isn't it? Why isn't that an approach?
I agree. I think, however, Your Honor, the key word here is selection. The question becomes whether the doctor selected between two recognized courses of treatment. In the Wecker case and the Lee case and this case, the doctor's own testimony was he never made a selection. He instead only ever decided this is the way it has to be. It's not a selection between, it's not a consideration in the Lee case. So the other side attacks my citation to Wecker as saying that that was an informed consent case. And there it was, the doctor only ever suggested one course of treatment, as if this can't apply in informed consent cases. Foster was an informed consent case too, and this was held appropriate because it was a selection between two different treatments. The Lee case, which is not an informed consent case, the 123.11 instruction was refused, and the Court of Appeals affirmed. There it was, the doctor never considered the course of locating and repairing damage from a misplaced catheter before performing surgery. And it was the failure to select. Selection was never an issue in this case.
So what's the testimony from the doctor that you're relying upon?
Sure. Dr. Eidenberg said that, record volume 7 at page 93. Doctor, the reason is you told us you didn't know what type of tachycardia Ms. Bigelow had, did you? Answer, correct. Question, and the reason you didn't know is because you didn't have an EKG on this patient. Correct. And he answers, correct. Record volume 7 at page 102. Question, okay, so in this case, you did not have the necessary test to go through and to rule out the more lethal tachycardias. Agreed? Answer, no, I did not. Record volume 7 at page 128. Question, you didn't know what type of rhythm and what type of tachycardia this patient had. Answer, correct.
So he selected, he selected the course of action that he would not test for that. As my colleague suggested, he selected the course of action that he would not test for that. He would not address the tachycardia symptom as a symptom. Instead, he would try to undercut it by addressing the causes. Isn't that a selection?
No, it is not, Your Honor. His testimony was not that he considered doing the EKG or not doing the EKG, considered doing a 12-line heart monitor or not a 12-line heart monitor. His testimony was solely that he didn't need to, that he simply didn't test it because he assumed it was a sinus tachycardia.
What you just read to me is that he didn't have an EKG, not that he. I mean, I don't think the testimony you just read supports what you just said. So do you have something else?
Did I perform the test? No, I did not. He never considered performing the test. He never
Saying I didn't do it is not the same as saying I didn't consider doing it.
he never testified that he considered doing it.
Did
If-
you
if
ever
he-
ask him? I'm just suggesting that what you're reading
Sure.
to us does not demonstrate that he never considered it. It only demonstrates he didn't do it. Do you understand what I'm saying?
He never suggested that I looked at two options and I selected the one I thought was the best. He said there was only ever one option, and that's the option I took. And that's just like the Lee and Wecker cases. Now, seeing that I'm running down on my time,
Just real quick,
Yes,
is
sir.
there anything about that instruction that prevents you from arguing as you are today that it didn't apply, that there were not two approaches selected, therefore you don't go to this instruction, you don't apply it?
No, Your Honor, there's not, but that's not the test for error. The test is whether it misled the jury. And having this and suggesting that there was a selection misleads the jury as to the
But
evidence.
even if we accept that there's error, why does that not make it, why is it a reversible error? In light of the fact that you could make the argument, the jury could reject application of the instruction if it was not factual, they found the facts didn't fit the instruction and that there were not two choices made by the doctor. Why do we reverse on this?
The standard for harmless for harmless error in a jury, or sorry, lack of harmless error, prejudicial error in a jury instruction is whether it confused and misled the jury. And just like in the Wecker case, where the same exact thing was held to have misled the jury because it didn't involve a selection, the same is true here. I'd like to turn, since my time is running down, to the fault instruction, or rather the definition of negligence and the fault instruction. To be clear, we agree, and always have agreed, that a definition of fault should be given in medical malpractice cases where comparative fault is not at issue. The 10501 instruction, which defines it, although it says it's for comparative fault, it's what the defendant had suggested here. It's what my client had agreed to in his proposed instruction, record volume 15 at page 9, that the defendant's negligence caused or contributed to cause the death of the decedent. That said, the problem was that the trial court put that below, instead of putting it in the 10601 claims instruction, or instead of putting it below the definition of physician's negligence, it added a definition of negligence for reasonable care, just for an ordinary person, as if it were a car wreck case or
And
something
my
like
problem with your argument there is I don't see where you called the trial judge out on that. I mean, I think this is really kind of a classic failure to comply with the statute on preservation. It seemed to me, this was Judge Henderson's case, right?
Yes, Your Honor.
Yeah, because we have so many of these, and some
Certainly.
of them it's easy to get confused. But it seemed to me that the judge was listening to, as I read the instructions conference transcript, it seemed to me the judge was listening to both of you guys as you're going back and forth on the instructions. And I think the judge would have listened to you if you'd have just said, you've got two definitions of negligence here, and I don't see where you said that. And so if you didn't say it, you didn't preserve it, and that's going to get you into the higher standard of review, which I know you don't want to be at. So tell me how you preserved this issue.
I see I'm about to run
Don't
out of
worry
time.
about
Okay. At the beginning of the instructions conference, the judge recounts that there was a lengthy discussion had off the record, and doesn't recount exactly what that discussion was. I appreciate this is not the best preserved jury instruction I've ever argued to a court either. However, the meat, the proof of what was argued is in what came out of this. That my client agreed that fault should be defined. He wanted it defined in his own instruction, and he objected to the court including this instruction number 8 at all. The only difference between instruction number 8 and what my client wanted was adding into the same definition of fault this definition of ordinary negligence. And in his final comment, the judge said, your objection to the definition of fault and negligence is overruled. It's pretty clear that this was, when trial counsel contacted me about appealing this case, one of the very first things he mentioned was this exact issue. I appreciate it could have been better done at the conference itself, but everyone was on notice that this was one of the arguments. And in fact, until his response to our supplemental brief in this court, My opponent never argued it was not preserved because he knew very well it was preserved. And he was the trial counsel in district court as well.
I'm
That-
sorry, you just said that it had never been argued by your opponent that it was unpreserved.
Yeah, until our supplemental brief, until his response to our supplemental brief before Your Honors.
Is this the case that the Court of Appeals brought it up for the first time?
That's exactly
Yeah.
right.
Okay. So if I'm just understanding you, I want to make sure I'm clear.
Certainly.
You're saying that the preservation issue is relieved, or that that there's adequate preservation because you proposed an instruction, your side proposed an instruction, and that instruction 8 as given is exactly as proposed but for the language that you're complaining about now.
I wouldn't put it quite that concisely, but yes, on the whole, yes.
We like concise.
I do too, Your Honor.
Well, I mean, to be more precise, the instruction you proposed did not have the definition that you're arguing about, regardless of what the other language may be.
That's correct, and both sides agreed to the 123.10 instruction about the physician's own standard of negligence, which was given as well. And at one point during the instructions conference, trial counsel for my client also argued that it would be appropriate to put the fault definition below that. I mean, it's pretty clear from the record he was arguing that this standard of negligence should not be there. He objected.
Regardless of what the standard of review is, you would agree, though, that the other instructions clearly told the jury to only pay attention to expert testimony when it comes to the question of healthcare provider negligence.
Of the healthcare provider's standard of care.
Standard of care.
Yes, but the standard of care itself isn't negligence. It's a violation of that. That's negligence. And so the real issue here, and I think again, if I may, thank you, Your
You're
Honor.
answering questions, so you can stand. You can stand there a long time.
Very, very, very kind, Your Honor. Thank you. My opponent, in his response, says, well, it's okay to issue two competing definitions of a term, and he points to the Foster case and another case from this court where both the physician's duty and then the medical specialist's duty were put into the jury instructions, and this court rightly said there's no problem with that because they're not inconsistent. The defendant when he's a medical specialist, right, a specialist physician is both subject to the ordinary doctor standard of care and the heightened one for a medical specialist. But in no medical malpractice case anywhere in this country, anywhere in the English-speaking world, is the doctor subject to the negligence standard for a car wreck case. It's not the lack of reasonable care. It's not the failure of a person to do something that a reasonable person would do. And I note that my opponent never once argues in any of his briefing that this is an appropriate or relevant, remotely relevant definition. This, too, misled the jury. Seeing I'm out of time.
I've got one other question
Certainly.
for you, assuming we're not testing the Chief Justice's patience too much here. But I want to ask you about your proffer on the
Yes.
safe medicine. I don't know how else to characterize it, but just the safe medicine argument.
Standard of care evidence, Your Honor.
It seems to me you've got three spots where the plaintiff's counsel wants to talk about this safe medicine issue, and I'm trying to figure out how the appropriate proffers were made for each of those three steps. So one's at the beginning, one's before trial, one's during trial, and then one's right before closing arguments. Those are the three I've identified, and if there's any others, jump in there.
I agree with you, Your Honor.
But, okay, so tell me where I look to see the appropriate proffer under the statute so that we can look and see whether this, if it is error, that it mattered.
Sure. I'm happy to discuss that. The first would be at the motion in limine conference. Frankly, I don't think that matters. I think this court's jurisprudence is pretty clear that even if an order in limine is granted, it's only advisory, and anyone trying to offer evidence despite the order in limine in order to challenge that order has to make an appropriate proffer when the evidence comes up at trial. So here, during Dr. Kaiser, which was the main expert for the plaintiff, during Dr. Kaiser's testimony, record volume 4, pages 80 to 82, trial counsel, Dr. Kaiser testifies starts to testify that patient safety, quote, underlies the standard of care. Defendant objects, says, Your Honor, this violates the court's order in limine from before trial. And for 2 pages of transcript, my trial counsel stands up and asks the court to reconsider the order in limine and allow in this evidence. Now, again, as with the jury instruction, is this the best evidentiary proffer I've ever seen? Absolutely not. I agree with that, and I think trial counsel sitting here at table also agrees with me on that. But is it good enough? The court standard from the National Bank of Andover case a few years ago is that all he has to do is apprise the district court of the substance of the proposed evidence and provide an adequate record to review when determining whether the trial court erred in excluding the evidence. Now, comparing what the objection was to the motion in limine with what counsel said on record volume 4, pages 80 to 82, that's certainly good enough. I mean, the judge knew very well what this was going to be about, and he overruled it on the same basis as having overruled what the objection to the order in limine was.
So in the motion in limine conference, if I remember correctly, there were references to the deposition transcripts that were this is where the defense argument is saying, look at these questions, and we don't want these questions polluting the jury. So you're saying take those and add them to whatever is in these 2 pages of argument, and that's your proffer as of Dr. Kaiser's testimony?
Essentially, yes,
Okay,
Your Honor.
so now get me to closing argument.
Closing argument is different. There, it wasn't, of course, evidence that counsel was trying to introduce. It was inferences and drawing argument from the evidence to the jury. That what we had here was the failure to take a basic safety step. This wasn't about the safest practice of medicine. This is a physician who has a patient who, after receiving a breathing treatment, her heart rate shoots up to 170 beats per minute, which he admitted was an unusually high tachycardia. And instead of doing the basic safety step, simple, cheap, effective, of just hooking up an EKG, which all of us have had at one point or another, he doesn't do that. He says, oh, it's a sinus tachycardia, and that's that. There's nothing wrong with trial counsel drawing the inference that it was below the standard of care for the doctor to do that. Now, he wanted to argue that to the court in closing argument. Not even my opponent has ever argued that that was insufficiently preserved. In the West case in 1986, the Court of Appeals says that an objection to a limitation on closing argument is preserved so long as the party objected before the argument began. Clearly that happened. Even Dr. Eidenberg in his brief says that counsel objected, quote, immediately prior to closing argument. That's his Court of Appeals brief, page 48. And that happened at record volume 10, pages 4 to 5. My trial counsel simply asked to be able to draw that inference from the record to the jury.
Counsel, I'd like to return you to the second issue that was discussed, and that was the negligence instruction. I believe it's number 8.
Yes, Your Honor.
There was some discussion about whether this issue was preserved.
Yes.
And I think you acknowledged that, well, your argument is yes, it was. I'd like to take you to the other alternative, which is no, it was not, which is a different standard for us to review, clearly erroneous.
Of course.
Assume with me, for argument's sake, that we agree that it was not preserved. Tell me how you went on that issue, if you have to show that this was not clearly erroneous.
Well, the standard for clearly erroneous is a 2-step standard. First, that it was obviously error, right? That it was clear and obvious error. And the second, that wound up in a manifest injustice. Now, this is not something I argued in our briefs because my understanding is I'm limited to what I argued in the Court of Appeals when arguing before this court. But if the court were to review this under that standard, I think we still win. It is an obvious error. The standard of the standard of negligence for car wreck cases does not apply to emergency room physicians in medical malpractice. That is a clear and obvious error, and not even my opponent has ever argued that this is an appropriate or relevant definition to be given. Manifest injustice is whether it doesn't have to rise to a constitutional error. We're in a civil case, obviously, but it is akin to a due process component, as some of this court's jurisprudence says. My client was denied a fair trial by this error because the jury was allowed to find the defendant not negligent under a simple standard. And although my opponent kind of poo-poos this statement in our brief, a juror could look at this and goes, well, it's the failure of a person to do something a reasonable person would do. Well, Dr. Eidenberg seemed like a pretty nice guy. I mean, he testified well, he looked well, he was well-spoken. I'm certainly not a doctor, and I think I'm a reasonable person, and I wouldn't have known to use a 12-line heart monitor when faced with the 170 BPM tachycardia. He might not have either. Reasonable person, I can go with that. That's manifest injustice. That's the denial of a fair trial.
And what is the case you're citing to us that says manifest injustice is our standard?
Your Honor, I'm going off of memory. I don't have one at my fingertips. I was not, I'll be very honest, I was not prepared to argue this under a clear error standard, but I'm going from memory from having handled clear error cases before in the Kansas appellate courts.
Perhaps during your opponent's argument, you get a chance to find such a case and then deliver that.
I would
during
love to,
rebuttal.
Your Honor.
All right, thank you, counsel.
Thank you, Your Honors.
Do we have any further questions? Thank you, counsel.
If it please the court, Stephen Day appearing on behalf of the defendant. Excuse me, the appellee. I will take this in the order that counsel took it, which means we begin with the choice of treatment instruction. I think it's important to note the circumstance at the time. PIC 12311 was still in PIC, still a recommended instruction, although it had been challenged many times. Recently, this court had ruled in the Foster versus Klauman case that it was an accurate statement of the law, but that it wasn't helpful in terms of some of the language. The court encouraged litigants to experiment, to look for better language, and also pointed specifically to the instruction in the Natkinson case as being a better example of how to instruct on this point. We essentially followed the court's suggestion and proposed an instruction that preserved the instruction to the jury that to the effect that where there's more than one recognized approach, that it's not negligent for the physician to choose one, but took out all of the subjective language that people had been objecting to and took out the reference to a physician's right that this court had objected to in the Foster case. I don't see how that can be error, but having said that, I also want to go one step further and make it clear that we aren't just arguing that the instruction was okay because the PIC committee hadn't yet taken away the 12311 instruction. We believe that that instruction is needed, period, and we respectfully disagree with the PIC committee. It is a basic statement of fact as well as a well-established legal principle of this court that within medicine there is usually, certainly often, more than one recognized approach to a particular problem. And the way that happens in the actual trial of the lawsuit is we have a plaintiff's expert who's up saying you should have done this. And you have a defense expert up saying, no, the way the defendant did it is appropriate. And then you have a lay jury trying to decide what they're supposed to do. And to that lay jury, it is going to seem reasonable and logical that their duty is to figure out who's right. But the jury isn't qualified to decide who's right, because this is an issue of medical and scientific knowledge beyond their capacity. So the law does not place that responsibility in the jury.
So in your position is that in nearly every case there are two more courses of treatment.
I think that's
two or more.
I think that's well established, Your Honor. Yeah, yes, in fact,
just by the basic premise of what a medical malpractice case is. There's the course of action that was taken, and then an expert would say no, that deviated from a standard of care. Therefore, a different course of action was necessitated.
I agree with that, Your Honor, but I also think it's just a basic fact of medicine that there's rarely only one way to skin the cat, that there's usually opposing viewpoints, and the proponents of those viewpoints will give you a very strong argument as to why they're right and the other side's wrong. And a trial of a malpractice case is not to resolve those sorts of disagreements. And what this instruction does is simply tell the jury that that's not their job, that their job is to figure out whether what the doctor did was one of the recognized approaches, with the additional language saying, but in making that selection, he has to exercise the care and skill of an ordinary physician in his field of practice. Again, basically the medical malpractice standard of negligence, which of course is something we can talk about later when we talk about the significance in terms of the second argument.
Counselor, how do we determine the options until we have a diagnosis? It seems here that the problem is, was it sinus tachycardia or some other kind? And in fact, we have an expert that says, hey, it was lupus pneumonitis. And that the courses of treatment that you would have ordered or would have followed if that diagnosis of the lupus had been made would have been different, right? I mean, those choices would have all been different. So I don't understand how we're arguing about an instruction on courses of treatment when it seems to me this all boils down to diagnosis.
Well, Your Honor, as we originally proposed the instruction, it included diagnosis, and the underlying case law on this issue would include diagnosis. But
are you saying that you have the choice of diagnoses?
Well,
I don't think you have. I mean, it's...
If there's more than one recognized approach to a diagnostic issue, then yeah, a physician, if it's a recognized approach and it's consistent with the standard of care, it's okay. But Your Honor, factually, I respectfully disagree. Factually, what plaintiff has tried to do is to get the court to look at this solely from his framing of the issue, which is that this is an issue about tachycardia. This wasn't a patient who was being seen for tachycardia. This was a patient who was being seen for chest complaints and for things that were diagnosed as being pneumonia. And the evidence is that the pneumonia, at least the defense evidence, that the pneumonia together with the breathing treatment is a reasonable explanation for what caused the tachycardia. So you have two different views on treatment here. View number one, asserted by plaintiff's experts, that you need to directly treat the rhythm. Give them a drug to knock it down. And then you have the defense position that no, the way you appropriately treat sinus tachycardia, which is what he felt to be present, is that you treat the underlying condition, and then the tachycardia will improve in response to that. There were clearly two different treatments, and that was the issue. But I also have to say, we're not living in the real world if we try to pretend that there is some clear distinction between treatment and diagnosis in the practice of medicine. They are an evolving process with the two things going on at the same time. And it has to be viewed, I think, realistically in that sense. Now, to move on.
Counsel, before you move on,
yes.
A quick question. I understand your argument to be that what I'm going to call this alternative approach interpretation of the standard of care is the law. And that's what you've said. You've said a doctor can satisfy the standard of care by following any acceptable alternative approach.
Yes, sir.
My question is it your position that the law requires the physician to have actively considered each alternative and then selected one, or that the physician just simply did one and not the other?
Well, first of all, I disagree that the evidence is that my client did not consider alternatives. It's clear that this was an evolving diagnostic treatment
But
situation.
My question is what is the law from your perspective?
I apologize, Your Honor. The law is quite clearly, I think, got to be based upon the reality of medicine, and choices of treatment are made at the time, but they're also made during residency. They're also made during fellowship. They're made when a physician is taught and when they make their decisions as to how to approach
Sure.
particular problems. I don't think that the bottom line issue here is whether or not the physician and at that moment thought about it. I think the bottom line issue is whether what he did was consistent with the standard
And
of
I
care.
understand that those are evidentiary type arguments. What I'm trying to zero in on is whether or not a physician can satisfy the standard of care without having considered all the options. And whether that consideration is, in the course of my whole career, this is how I arrived at this, or
certainly-
at the moment. My question is, could a doctor come in and said, and testify, I've never even heard of that other approach. I never thought of it once in my whole life, but I still followed a course of treatment that is recognized. Does that satisfy the standard of care?
Your Honor, that's a difficult hypothetical to respond to, but I do believe that I have to emphasize that we're talking about an objective standard of care. And what the jury is supposed to be doing is looking at what the doctor did and whether or not that fell within a acceptable approach that is consistent with what a reasonably prudent person in that field would do under those circumstances. And I think it's that objective issue that's more important than the subjective.
You see the ambiguity in 123.11 that I'm driving at.
I understand where Your Honor is coming from, yes, sir. And I think it is my position, for whatever it's worth, that that ultimately the issue is whether or not the doctor's conduct fell within one of the acceptable approaches. Now, moving on to the issue of the negligence instruction, counsel is right that we didn't really discuss that in our briefing. We argued the merits. I'm not going to argue about that, but obviously that's something that the court could bring up on their own. The court did bring it up on their own, and there's no question that the Court of Appeals was correct.
We've also been jarry about doing that when it's not raised by the other party lately. That's why we asked.
Okay, and I understand, Your Honor, but I mean, I think it is clear that the issue was not preserved for appeal. I don't think that I need to argue that at any great length. There is nothing in the record where the specific objection that's being made on appeal is being made. But I'm very happy also to defend this on the merits, which is, I think you need to look at the specific language that we're talking about, and I have a copy of the instructions in front of me, and if the court will bear with me for just a moment, we start off with the basic instruction of negligence, which was given because that's how PIC does causation, and that's why the judge did it. The PIC does causation by putting this caused or contributed language, which we will object to in another context, but they put that language in there as part of defining fault, and fault is negligence with causation under Kansas law. That's why it's there. But what the jury is told here is negligence is a lack of reasonable care, failure to do something that a reasonable person would do. You flip over the very next page, and we talk about the physician instruction, which is 123.01, and notice that this instruction really involves two separate duties on the physician. If you read the whole thing, a physician has the duty to use the learning and skill ordinarily used by other members of the same field of medicine in the same or similar communities and circumstances than this. In using this learning and skill, the physician must also use ordinary care and diligence. There is no substantive difference between this statement of that the physician needs to use ordinary care and diligence and just the general definition of negligence. What this instruction...
I think what your opponent's focusing on, though, is the reasonable person language.
Well...
As distinct from a professional with special training and experience, and that's what's troubling him. And I have to tell you, I share his concern that just having another instruction that zeroes in doesn't necessarily cure the original problem.
Well, Your Honor, first of all, I guess this is one of the places where I do wish that there had been a good objection, because I think you can even tell from the transcript that I was perfectly open to doing this a different way.
Right.
And
I mean, really, the fix was to pick up the fault and put it with the next instruction, and you're good to go.
Or just put in a reference to the to the next definition. But I mean,
Right,
yes.
for the definition of
So
negligence.
I'm a little bothered that we're making this argument. I really didn't have a chance to deal with it at the time of trial because this has been done in other situations where people haven't complained because it's kind of how Pick sets it up, and we tend to just kind of default to Pick.
Yeah.
But I also, because I'm running out of time, and I would have liked to address the other issue too, but in this circumstance, I think it is very important for the court to look at the fact that several of the subsequent instructions restate the duty of the physician. Every expert witness talked about the duty of the physician. Even their allegation or contention instruction incorporated the standard of care. Arguments were all about that, and the suggestion that this confused the jury, that the jury somehow thought that they were really deciding something on the basis of a car crash case standard, is just not realistic. It's not real world. There was no prejudice here.
You're talking about instruction number 11 as one of the examples?
Your Honor, yes, 11 is applicable. Frankly, so is 14, where it says the defendant failed to meet the diagnosis, failed to provide diagnosis and treatment to Charlotte Bigelow that met the standard of care. That's plaintiff's contentions. And curiously enough, even instruction 15, which is the one we were arguing about previously, that last sentence is a word-for-word restatement of the general standard of care applicable to a physician. So all of that is there, plus the way it was argued, plus the way the evidence went in. The prejudice just is not reasonable. And again, there are other things I could talk about, but I am out of time. Thank you.
Do we have any more questions of counsel?
I'd like to hear you address your other issue.
Okay, with the court's permission. Your Honor, I'm going to try to do this briefly, and that's maybe not that easy to do, but this is this reptile litigation thing, and I know courts don't like it when you talk about trial tactic things, but when it involves fundamental rights, and when it's an exploding thing out there, Google it, you'll see that it is. It's a really big deal. Then I have an obligation to protect my client. And if you read this book, and you look, and it's in evidence in another case, and if you look at this theory, there's no question that the whole purpose of this theory is to convince the jury to decide the case on an improper basis. And that's not an argument, that's not a supposition. I tend to say this 330-page book is a signed confession. It's right in there. That the purpose is to convince the jury to decide the case, not on the facts of that case, but on the basis of what is going to make the community and therefore them and their families safe. And that's improper.
It seems like, though, that this boils down to the use of one word. And safe or safety has become just a word that cannot be used. And I'm wondering if another word is substituted, does that cure the problem? As it was used in this context, I don't know that the word was used to infect the jury with the idea they have to protect the community. I didn't see that as it was being used in this context. Is the problem the word?
No, the problem is the use of the word in the portions of the deposition that we pointed to as showing pretty clearly that this was going to be used, that the reptile litigation technique was in play, including the phrase about needing to avoid needlessly endangering a patient, which is an absolute identifier that that's what you're dealing with. But there's also the question of does a doctor basically have a duty to pick the safest alternative to treatment? And that is fundamentally misleading, because a doctor has a duty to use the care and skill of a similar situated physician.
Well, counsel, I understood the argument wasn't on the duty, but on the standard of care.
Well,
and that the argument is that the plaintiff's expert was going to testify that erring on the side of patient safety is a component of the standard of care.
Your Honor, and I guess we have a fundamental issue there is whether or not making a statement that a physician has a duty or an obligation to err on the side of safety, or has an obligation to do one of these broad statements that are disconnected from the facts of the case. Is that testimony as to standard of care, or is that creating a standard of conduct, a duty that interferes with the right of the court in terms of instructing the jury? And we respectfully submit and strongly submit that it's the latter. When a lawyer makes an argument, or especially when an expert offers testimony and says that we as physicians must pick the safest possible alternative, that's changing the law. Because the law is that a patient has to, a physician has to use the care and skill under those circumstances of a similarly situated physician. And there are significant public policy issues here. If it's really true that a physician has to pick the safest thing, that they can't consider what's reasonable, that they can't consider what is, what makes sense.
The balance of risk and reward. I mean,
Yes.
isn't that really what medicine's all about?
Well, it is, Your Honor, and it is the balance, but the example, and I don't want to get into a different case, but you have a situation in which you can say a particular sonogram is relatively safe, so why not do it on everybody? Because that's the safe thing to do. But it also, of course, would drive up costs. It would result in unnecessary hassle for the patient. It would mean the equipment isn't available for other patients who really need it. And that's why it is so fundamentally misleading to try to say that this is all about doing what is safest. And what the judge was doing here was...
Here's my question, Mr. Day. I mean, even if we agree with you that that's not really what the standard of care is about in med mal litigation, isn't that something you can argue to the jury and explain to the jury just as you've explained it to us? And is it really necessary for the court to intervene before the evidence even comes in? That's what I'm struggling with, because I think you've just eloquently described why it shouldn't matter.
I guess I don't think that eliminates the prejudice, number one, but number two, do you really want trials to be debates regarding what the standard should be as opposed to what the standard is? Because that's what we're talking about. If we start saying that, I'm up there saying, I'm going to have to make improper arguments. I'm up there saying, if they're saying that you have to do what's safe, I have to get up there and say, well, if you do that, what they're saying is going to drive up costs, and it's going to do these other things, which is not the arguments you're supposed to be having. You're supposed to be deciding whether under the objective standard of care, the action he took was consistent with what a competent healthcare provider would do under those circumstances. I believe that in this case, the judge, in what's somewhat difficult to do, came up with an approach that he thought was fair to both parties in exercise of his discretion. And in doing so, he went overboard, in my opinion, in saying, please come to me if you have any questions or concerns. And it really wasn't done for him. There was never a situation where here is the substance of something I want to put on that I didn't. And please allow me to also note, since I'm, in addition to trying to argue a policy issue here, I'm trying to defend a client, that in this circumstance, plaintiff had a full opportunity to put on their whole case. You can't look in the evidence and see anywhere where their experts were in any way limited in their ability to talk about what was done wrong and why it was wrong and how it could set the plaintiff up for the injury. There was a very aggressive closing argument given.
Dangerous.
All these things.
Which is another problem with all of this. This is kind of the futility of trying to limit ahead of time when you can just use the opposite word. You can just use the antonym and accomplish the same purpose. If one credits the reptilian science, which it looks a little weak to me based on what I've seen so far, you get around it so easily.
Well, and I think that you don't have to accept the reptilian science, which I agree is questionable, to not understand that an approach that tries to get the jury to decide the case on the basis of fear is bad.
Yeah.
But
Okay.
yeah, it's a hard thing to craft an order in limine on that protects, which is maybe why, which is really going to cover everything, which is perhaps why a number of the district court judges in the federal districts, when they got these lengthy motions in limine with a bunch of stuff, and one of them was reptile, and the cases cited by plaintiff, mostly said, we'll take it up at trial. You know, and it's, I'm warning you, I don't like what this sounds like. I don't think you should be going there, but we'll take it up at trial. But that's a discretion that was exercised, and I don't think that this exercise of judicial discretion can possibly be said to have met the definition of abuse of discretion, and certainly it didn't prejudice plaintiff under the totality of the circumstances. And I appreciate the court allowing me to respond on that issue as well. Nothing else. Thank you.
Counsel, we did take up a lot of your time with our questions. I'll give the same courtesy to opposing counsel. Do you need 30 seconds to wrap up, or do you believe you've made your position clear?
I appreciate it, Your Honor. I think we've covered the three issues here. I think that plaintiff received a fair trial, and I think that I have adequately addressed the issues. Thank you, Your Honor.
Thank you. You reserve 3 minutes for rebuttal.
May it please the court. Thank you, Your Honor. First, Mr. Chief Justice, you asked me to find a case about the clear error standard of review in the short amount of time, well, longer than usual amount of time I had while trying to listen to the court's discussion with opposing counsel. I was able to find instructional error in criminal cases, and I was right, there are two prongs. I misstated the second one slightly. This case would be State versus Brammer. It's from this court in 2009, 301 Kansas 333, 343 Pacific 3rd 75. The first prong is, as I said before, to determine whether there was an error. And the second prong then is when the court is firmly convinced the jury would have reached a different verdict had the error not occurred. And as I say, this is a criminal case. The standard, it's under a Chapter 22 statute. Standard may be slightly different in civil cases. If the court would like, I'm happy to send a letter after argument. But I think with that in mind, the argument that I previously gave works.
The argument that you made about manifest injustice, let me finish, please.
Yes.
The argument you made, assuming the standard was manifest injustice, you're transferring over to this standard to the court not firmly convinced the jury would have reached a different verdict even if provided the instruction at issue constituted error. Is that what you're telling me?
Yes, Your Honor, because the question still remains, did my client receive a fair trial? Was the jury, would the jury have gone the other way but for, is there a reasonable probability, is the court firmly convinced that the jury would have gone the other way but for the error? And here, I note that in his argument, my opposing counsel, again, didn't argue that this reasonable person standard that, say, would be applicable to an ordinary negligence case was applicable here.
He said it was fine with him.
He said it was fine with him.
He said it would have been fine with him, and he wished he'd had an opportunity to discuss it in the trial court, but the preservation error prevented that. So
I agree,
you're headed somewhere you don't want to go.
That's fair, Your Honor. That's fair entirely. Then I won't go there, and I'll leave it to what I've already told the court about that. But since
I'm sorry.
Yes, Your Honor.
I'll give you time, even though we're eating up your time with our questions.
Very kind.
Would you address the point he made that seemed to be, well, gee, how could the jury have been confused? How could this error, if there was, made any difference when there are other instructions here that keep talking about the physician's standard of care, physician duty of care, and that is balanced against this one instruction that talks about the reasonable person? Can you address that? Or if you felt you already have, then I'll let you continue with your...
I certainly can address it, and I'll do it briefly. The court likes being concise. The jury is instructed, first and foremost, at the very beginning of the post-trial jury instructions, that it has to follow the instructions as written. The jury is further instructed that in looking at the evidence, they can use their own standards for credibility, and that's not up to courts or counsel to argue to them. With all of that in mind together, what you have here are two inconsistent jury instructions, both defining the same term. The jury is instructed to follow the instructions as written. If I'm an ordinary lay juror with no knowledge of the law, and I see first, what is negligence? Negligence is the lack of reasonable care, the failure of a person, etc. And then later down the road, I see in determining, I see a physician has the duty to use the learning and skill ordinarily used, etc. I have one definition that applies, and one that legally doesn't, but that I'm told by another instruction does apply, because I'm supposed to follow the instructions as written. We cite a bevy of cases in our Court of Appeals reply brief and our supplemental brief in this court from around the country, unfortunately there aren't any in Kansas, where the same term was defined twice, one with an applicable definition and one with an inapplicable definition on mistake. And in all of those cases, the courts at issue reversed, holding that, so for example, there's the most recent one is from Missouri in 1992, the Missouri Supreme Court, Rogers v. Bond, and that was about lack of ordinary consent and lack of informed consent. One applied to the case, one didn't. On mistake, the court gave both of them. The Missouri Supreme Court held that that was error. The same error is true here, and for exactly the same reason. Now, since the court is being courteous and giving me some extra time, I'd like to address in a little more, since all we really got to on it at my opening was the preservation aspect, this safety, this standard of care issue. To start out with, opposing counsel characterizes this as testimony that the doctor has the duty to do the safest thing. Not once in any deposition testimony that he pointed to, and not once did anyone ever say that that's the issue. No one says that the duty of the doctor is to take the safest approach. It's to err on the side of safety. It's to not needlessly endanger the patient. This is a standard of care issue. The standard of care, as this court made very clear in the Nold case, which we discussed in our briefs, is an issue of fact. It is not one of law. It is not something on which a directed verdict can be given. It's something on which, frankly, a plaintiff's expert, if he's an expert and he's qualified as an expert, he can testify the standard of care is whatever he thinks it is whatever he and his expertise finds it to be. And if the defendant is able to bring up his own expert to say, for example, the standard of care did not require taking that safety step because doctors, as part of the standard of care, have to make the practice of medicine accessible. It can drive up costs. The defendant's counsel gave the extraordinary statement to the court that trials aren't supposed to be about what the standards of care should be, but rather what they are. But we're always in a medical malpractice case fighting over what the standard should be. One doctor says the standard is this. The plaintiff's expert says the standard is erring on the side of safety and taking basic safety steps. The opposing expert, if he can testify that that's not part of the standard of care or can temper it. These are factual questions and they're up for the jury to resolve. With that said, no one has ever argued there is a legal duty of a doctor to take the subjective, safest approach. Frankly, what the safest approach would also itself be a question of fact for the jury. These aren't injecting legal issues as... Again, I know that opposing counsel wants to downplay the list of federal district court cases I provided the court in our supplemental brief, but not all of them are just one line, reptile, whatever reptile is. My trial counsel has never read the reptile book. He had no idea. He said he'd heard of it in the transcript, but he's told me, that this was never an issue. I agree, the reptilian brain things, to me, it sounds silly. But this isn't a conscience of a community argument. It's simply a doctor being able to say, if it fits the standard of care, that the standard of care requires taking this step because there was no reason not to, and it would have. It's a basic safety step. There's nothing wrong with that. as every single court to have looked at this issue has found. Now, I'll note that opposing counsel in his response to our supplemental brief cites one case, I think it was called Pasha, from the Western District of North Carolina in 2015. There is a one-line thing that says, motion in limine as to reptile arguments granted. Never says what reptile arguments mean. Later down in the same exact order, the federal district judge says, motion in limine about safety first, she uses the term safety first, is denied. So I don't really think that's dispositive either. The only courts ever to have mentioned this have denied these kinds of orders in limine because they're sweeping, right? You have, as one of your honors said, not allowing a lawyer or any of his experts to use a word, to use the word safe. That's crazy. I mean, how many times can the word safe come up? We talk about in all kinds of negligence cases that the standard of a driver is to obey road safety, not necessarily to do the safest thing where you have, you're going down the road, there's a barrier, and on one side there's one group of 2 children, and on the other side there's one group of 3 children. Which option do you take? We argue about what a safe driver should do.
How was your side of the case hurt in any way by the motion in limine as it was fashioned by Judge Henderson? Your opposing counsel pointed out that he went to, I thought, pretty great lengths as well, to be fair, give everybody a chance, give your side a chance to come back and argue why the motion should come out the other way, etc. And your trial counsel argued repeatedly in closing about how dangerous the behavior of the physician was here. How were you hurt by this? Weren't you able to get around it handily?
That's simply closing argument. And again, the jury's instructed that the arguments of counsel
And
is
I'm
not
trying to
evidence.
talk about harm.
I understand.
I'm trying to talk about harm.
And that's what expert witnesses in medical malpractice cases testify about. The harm here, the harm to my client, was that the entire standard of care, a question of fact, was unable to be fully discussed to the jury.
But it wasn't, because your trial counsel argued repeatedly that the standard of care had been deviated from because the dangerous behavior had occurred.
And that was merely the argument of counsel. It was not the testimony of the experts that counsel could reference. The testimony of the experts was hobbled. It was gagged because
How was it hobbled and gagged? I mean, the plaintiff's expert testified that the defendant's actions violated the standard of care.
Violated what he was allowed to say the standard of care was. He wanted to say, Dr. Kaiser wanted to say on record, volume 4, page 80, that safety underlies the standard of care, and then go into what
And that's what opposing counsel is suggesting, is injecting a legal statement as under the guise of factual testimony.
As my trial counsel's proffer stated, what he wanted to testify was that needlessly endangering a patient and not erring on the side of safety when that is a reasonable option is a component of the standard of care. Again, these are questions of fact, not law. And if the defense can have their own expert who testifies that is not the standard of care, that's the cure. That's the cure. But he was hobbled because he wasn't allowed to say that. He wasn't allowed to testify that that is the factual standard of care, that time and again, we cite this great Illinois appellate court case, which says you can't have directed verdicts as to the standard of care. And that's essentially what the defendant was asking for here, was a directed verdict as to what the standard of care was. That's a factual question and not a legal question.
Counsel, I think you've made your points.
Thank you, Your Honors. I think I have two. I thank you for the courtesy, and we'd ask the court to reverse the Court of Appeals and reverse the District Court.
All right, thank you, counsel.
Thank you, Your Honors.
Thank you both for your arguments this morning. The court will take this matter under advisement.